morning and a warm welcome to all of our Legal for Landlords and buy-to-let broker landlords who've joined us today. It's great to have you with us for the first in the series of our webinars covering the Renters' Rights Bill. Over the past few months, we've seen a period of uncertainty and concern for landlords, largely driven by the ongoing changes, both in terms of the content and the timing of the Renters' Rights Bill. With so much still evolving, we understand how important it is for our landlords to have clarity and understanding on what to expect and how to prepare for the changes. Today's webinar is designed to do exactly that. We are going to be addressing some of the most common questions and key topics that have been raised by our landlords to help you stay informed and better equipped to navigate what's ahead. We're also going to take the opportunity to introduce you to our specialist team, the people behind the advice and the support that we offer, who are here to help you manage change with confidence. Firstly, I'm pleased to introduce Martyn Taylor from Ashley Taylors.
Hello.
Martyn is one of our valued legal partners who provides us with key expertise and guidance on a wide range of landlord and tenant matters. His depth of knowledge and practical experience have been instrumental in helping us to respond and interpret the evolving legislative changes. Today, Martyn is going to provide us with a clear overview of the Renters' Bill, the recent changes, and also the anticipated next steps for landlords and timescales. So I'm now going to pass you over to Martyn, who's going to set the scene in terms of where we are and what to expect over the coming weeks and months.
Thank you,
Martyn.
Thank you. So, first thing to say is an unusual thing to say, actually, was for talking about an actis that Parliament hasn't yet passed the Act. And it's everything's not set in stone, and what we're going to talk about today could change. Unlikely to, but it could change. Everyone knows that the Section 21 is going to go. It's been so well advertised. And the question will be, when does it go from? So when acts are passed, that isn't the date the act actually comes into place. So what we're looking for is something called the commencement date. Currently, the act is probably going to be passed in June or July, which means that its commencement date could easily be September or October. And it's the commencement date we're interested in, and your clients will certainly have to know that. Because on that commencement date, whatever else the government's going to do at the moment, assured short-of tenancies will cease to exist. They will all become periodic, which is an older style of tenancy, looking back actually pre-88. Your ability to use Section 21 will go. So well advertised, and you don't want to talk about it too much, but we just need to talk about a couple of things. Because the tenancy is now going periodic, that has a major effect on the tenancy itself. So you have a term, the term is gone. You have a break clause, the break clause is gone. You have a minimum term, that's gone. You have a clause for increasing the rent, that's all gone. Even if it's there, it's gone. The new tenancies going forward can't have that. Some of you will say, well, I've got my Section 21, it's been served now, and the Act's coming in 2 months' time, can I still use it? The answer is yes. There is going to be a transition period. Don't ask me what the transition period is, because I have seen two, one saying 2 months, one saying 3 months. It'll be in the Act. But definitely you will be able to use your Section 21 for a time after the Act, if it's been issued before the Act's commencement date and it's still valid. And I would expect probably when people have that commencement date a month before, you're going to be inundated with Section 21 notices, because they don't have to operate them, but they're just going to have it as a safety net. The one thing to say is also that when the periodic tenancies are new tenancies you take out after the commencement date, they're going to have to last at least 1 year. You can't serve a notice prior to that year unless there's a breach. And a breach means something like not paying rent, or they've done something they shouldn't do, or vice versa. So that's the key thing about that. They're going to be there for 12 months. If they're doing what they should do, then you can get them out. If you want to sell the property, or you want to give the property to your family to live there, you can do that. Section 21 is replaced by Section 8. The Section 8 has grounds, reasons, and you have to have a reason. The no fault part of the Section 21, that's gone. But that's how that's going to work. As an automatic follow-on, because it's periodic, rent increases now are very, very strictly governed by law, Section 13. You can only increase the rent once the tenant has been there at least 12 months. You must give them at least 2 months' notice, no more than 4 months' notice. That's the easy part. The difficult part, the tenant can challenge it. And if you don't agree, the tenant can challenge it to something called the first tier tribunal, FTT to us. And I'm not going to make any bad comments about this, but they're very, very slow. And if the tenant challenges it to the FTT, and the FTT take 8 months to say, yes, the rent increase is correct, or should be more, or should be less, it's not backdated, which means that there's going to be an industry out there to say, tenants, just challenge it, you've got nothing to lose. That's how it's going to work. That's one of the things we're not happy about in the Act. There is some resistance to it. There's not yet enough resistance to it. Deposits, mechanisms for taking deposits is not good to change. And the mechanism for protecting them is not going to change. But be aware that currently, the way it's written, when you bring up tenancy, you can't take rent in advance before the tenancy is signed. So you can take a deposit for the tenancy signed, but you can't say, let's give me that month's rent now and we'll sign it next week. Tenancy has to be signed. And once the tenancy is signed, they have the right to occupy the property, which leads on to some thoughts about, so if they sign the tenancy and they have the right to enter and they can't pay, how does that work? So they have the right to go in. So do they go in with arrears? That's got to be looked at. So there are some key things to look at. Regulatory things, just for people to understand. Little things. One, the rent you have to advertise the rent. The rent you advertise that is the rent you're going to be taking. You can't increase that because someone's come along with a higher rent. And you can't decide that you don't want to rent to someone on benefits because you've got two people. Let's just take the cliche. I've got a banker, I've got someone on benefits. Which one do I rent to? You can't decide to rent to the banker because you don't want the benefits. How that's going to work in law, no one knows, because in theory, you could bring up lots of discrimination claims. And if I was on benefits, I would say, you're discriminating to me. And there's something called the Discrimination Act. How does that work? It's not there. So they've got to look at this. And remember that if it is discriminatory, it is illegal, it's a problem. The final thing that I just want to talk about briefly is landlords are going to have to register with, we're going to call it a landlord's portal for the moment until they give it a full name. That's where you're going to register your deposit, your PI, your EPC, your UICR, GSC, which I'm hoping all your clients should know those initials. Everything should be there so that if it's there, you've complied with the regulations. You can't rent if you haven't complied with the regulations. It is compulsory. Of course, there's a fee to join it. It's compulsory. If you rent and are not a member of that, then you will get fined. If you haven't complied with the regulations, you will get fined. If you do it too much, you will be banned from renting. And then you will get fined, and then the whole thing becomes a bit academic as a landlord. So that's kind of my overview for the things that are coming out. There's a lot more. There's no point talking about it just yet. We need to just see this go through. But those things you can say, they're going to happen. Okay?
That's great. Thanks, Martyn. Very informative, as ever. So next, I'd like to introduce you to Matthew. Matthew Rowan, one of the founding directors of the Buy-to-Let broker. Matthew has been instrumental in shaping the Buy-to-Let broker into one of the UK's leading specialists in this space. His insight, leadership and deep understanding of landlords' needs have helped to establish this business as a trusted partner for both new and seasoned investors across the UK. We're really pleased to have him with us today to share his perspective and to feedback to everybody on the webinar, his experience of concerns that his landlords have raised over the recent weeks and months. So over to you, Matthew.
Yeah, I'm going to touch on a lot of what Martyn touched on, more from the landlord's perspective, because everything Martyn said was absolutely spot on, but obviously we see it from our advisors will see it from how that creates reciprocity in the landlord community. And obviously to have a healthy PRS and a healthy private sector, we need landlords. And probably the biggest concern from landlords, and we do see a slightly different demographic, I have to be honest with that. So most of our landlords are quite experienced landlords, and they have done the research, they have done the reading into this. But we have a bit of legislative policy coming in here that's creating residents for new landlords coming into the market, and there are also smaller landlords who are entering the market, and the statistics are showing that. The Section 21, which is commonly called no fault eviction, and it of course creates great residents because landlords want to know they're able to get their property back. It has been offset hugely by the watered down Section 8, and people do have the ground to get their property back, albeit if they want to sell the property or move family members in, then they would need to give a 4 notice period, which I think is fair when you're considering people's houses. But my biggest issue with that is, we deal with ethical landlords, and I think most landlords are ethical. There are bad apples in there as there are in any industry. But this no fault eviction it creates a huge stigma in there. And the bottom line is, and it's moving to periodic tenancy, which I'll get to in a minute. But generally, tenancy is on a 6 or 12 month AST or a short tenancy agreement. And that contract is where both it gives stability to the landlord, stability to the tenant, and the idea is that both know that they have security for that 6 or 12 month period, and then after that, should they wish, they can either renew to another tenancy, or they could go on to a rolling 1 month contract. If I'm renting to Martyn and we agree on a 12 month contract, and he's happy with that, I'm happy with that, at the end of the 12 months, we carry on, and Martyn still wants to live there, I'm happy, and we've got 1 month's notice as we go, and then Martyn decides he wants to move out, he wants to upside, whatever it may be, and move with jobs. If he served 1 month's notice, or if I want to sell that property and I serve 1 month's notice, that was all part of the agreement, that's what we agreed to. So if I serve notice on Martyn and give him a month's notice, he's had the 12 month after, we've done a month after that, what we agreed to, it isn't no fault eviction. That's just the terms of the contract we're both adhered to. And it's a strange example, but the only example I can put it to in a corporate environment, if I came with a 6 months fixed contract consultancy with you, man, and we agreed on 6 months with a 1 month's notice period at the end, we get to 6 months, we do another month, you'd say, right, we'll finish the project, that's fantastic, we're actually sent to it. I can't take no fault redundancy. And it's a real fallacy, and landlords have the right to have the property back if it's done reasonably with the right notice period. And I don't think that phrase of no fault eviction was done anyone within the private sector. But I do think there's a watered down Section 8. I really think the landlords that have done their reading on it are quite comfortable with that, and I do think changes are beneficial. Then we move to periodic tenancy, which Martyn quite rightly brought up, which is the second biggest question that we see from landlords. In terms of does it kill their fixed term planning? And to some degree it does, because as Martyn quite rightly says, from their perspective, they've got to give 12 months, but from a landlord's perspective, from a tenant's perspective, if they wish to give 2 months notice, they can give 2 months notice.
Yeah.
What will that do in real terms? What will it practically do? Well, I actually think it will improve the state of the property in the park register, because what it's there for, and what it will do is people will no longer be stuck for 6 or 12 months in a property that isn't of the right standard, or isn't maintained the right way. While a landlord who doesn't look after the property, they will be forced to do that, otherwise tenants will sit there notice. So I actually think that's really healthy for change. And I think if it's managed right for good landlords, and you deal with good landlords, it'll be right. The rent rise, again, is an interesting one. I'm kind of split on it. The one rent rise a year, I'm kind of okay with. I'm kind of okay with it being a fair market rent, although as Marsh quite rightly said, I'm not sure the STT can deal with this right now. But I'm also a bit of a free market person. I do believe if you've got a service that you want to charge more than competitive, and you feel that your service is better, you have every right to charge that. The problem you've got is that wasn't introduced. It would conflict with the removal of Section 21. So if a landlord wanted to remove a tenant, they couldn't forcibly do it under the guidelines. They could just put the rent to something that is non-sustainable and non-reasonable, so £5,000 a month rent. Yeah. So it kind of had to come in line with that. It's quite interesting. It's very tenant-centric in the fact that if it goes to the FTT and the FTT say, actually, that's under market rent, the landlord isn't allowed to increase it to that. But if they believe it's over, then obviously, then the landlord would have to remove that increase. And then the final bit I want to put in is, which is really important, is the removal of rent in advance. there will be restrictions that way. You can't get 6 or 12 months no pay front. And it's interesting, it tied in with that you can't discriminate against people with benefits or perhaps or anything else. Now, the private rented sector houses society's most vulnerable. There's a lot of people who rent by choice now, there's a lot of people, especially with the mobility of workforce now, a lot of people who rent by choice. But without a doubt, it houses society's most vulnerable. Society's most vulnerable, generally speaking, being really general, people on benefits, single parents, people who've had financial difficulties. Depending on where you take statistics from, nationwide, right now, there's anything between 15 and 21 people per property with a property owning electoral market, right? So if you are the landlord, it's nothing to do with discrimination, but if you're the landlord and you've got a banker on 100 grand a year, or you've got a single parent you want to help out, but single parent, financial difficulties in the past, on benefits, the only way those people were able to secure those properties in a market less heated than it is now was to say, well, I'll pay 6 months up front, or I'll pay 12 months up front. And actually, it worked, and it meant that these people had a real fair chance of getting those properties. And the very people that this legislative change is there to protect, damaged by that market. And there is not a chance that a landlord, not from a discriminative point of view, just from a common sense commercial point of view, will let someone in financial difficulties, a single parent, over someone on 100 grand a year, if they don't have the ability to pay that rental. So I think it needs to be looked at. I'm not sure it will change. I'm with Mark, it'll change, but I think it will have a really negative impact. And until there can be more housing, which is a different subject altogether, that's a problem that is going to go away.
Absolutely. It's really interesting, that point, Matthew, because I know that some of the large letting agents that we work with, maybe 50 to 20% of their applicants end up paying upfront because they don't fulfil the criteria for the standard referencing process. So it's, as you say, it's going to be interesting to see how that's managed, because it seems to completely contradict the whole ethos of what the Renters' Rights Bill is there.
It was actually the very people it's there to protect.
For sure, 100%. Brilliant. Thanks, Matthew. That's really, really helpful to get your perspective from your landlords. And finally, I'd like to pass over to Bex. Bex heads up our specialist professional services team. So welcome, Bex. Bex has played a vital role over the past few weeks and months in supporting and reassuring our landlords around the uncertainty with the Renters' Rights Bill. She's been closely involved in handling many queries, reassuring our landlords. So Bex is now going to cover some of the common questions that we've received from our landlords over the last few weeks and months. So over to you, Bex.
Thank you. Yeah, it's a great opportunity to address and clarify some of the common questions that we have received from our landlords. As Mark said, I work on the eviction debt recovery side, and we also cover all compliance. So we are receiving every day all sorts of different questions, and we thought we'd just address the most common. So starting with, how do I get possession of property once the Section 21 has been abolished? So as both Matthew and Martyn have already clarified, it will be a Section 8 notice. So landlords will need grounds and a reason to evict. We believe the most common grounds that will be used going forward, aside from rent arrears, will be ground 1 and 1A. So ground 1 will be amended to where landlord is moving into the property or landlord's family is moving in. And ground 1A will be when the landlord wishes to sell the property. Some more updates, I won't go into too much detail, but we know at the moment Section 8 rent arrears grounds, currently a 2-week notice. We know that will be increased to a 4-week notice. So definitely big changes there around the evictions. In terms of proposed changes to ASTs under the bill, so we know that ASTs will be minimal. They'll all be moving to periodic agreements. So they'll be monthly rolling. The only way that the agreements will end is if the tenant served notice, or if the landlord relies on the Section 8 notice and sees that process through. And it is important to note that current existing tenancies are expected to become periodic overnight when the bill is in place. Once the bill comes into place, what will be the required notice period under grounds 1 and grounds 1A? So we know that the notice period will be 4 months. and we know that landlords will not be able to rely on those grounds for the first 12 months of a tenancy. It is important to note as well that if landlords do rely on grounds 1 or 1A and don't even move into the property or sell the property, then they won't be able to re-let the property for 12 months after the notice expires. So that is really important for landlords to be aware of. In terms of how much advance notice landlords will be given prior to the bill, so as Martyn has already covered, there is uncertainty around this. At the beginning of the year, there was a lot of talks around this coming into place in summertime. A more educated guess at the moment is towards the end of the year. So October onwards, we don't believe anything's going to be in place summertime as it stands at the moment. And finally, if Section 21 is served prior to the bill, can this be relied on when seeking a possession order? So the short answer to this is yes. However, if the Section 21 is served prior to the bill, there will be a window where landlords will need to receive support off that notice. And we believe at the moment this to be a 2 to 3 month window. Again, not set in stone, that's just what we believe that to be. What I would advise, if you are looking to sell the property, if you're looking to get possession of the property, then serve the Section 21 sooner rather than later and get that in place before it's too late. Of course, it's always advisable to follow the official government updates. If you're registered with ourselves, we are continuously sending out all of the updates as and when we receive them. So if you're not registered, then definitely head to our website and register with us.
Brilliant, thanks Bex. So some really interesting feedback there, so thanks for that, and quite a bit of overlap as well, I think, with what Martyn and Matthew have said. So you can really help, thanks Bex. So as we come to the end of today's webinar, I'd like to thank all of the participants. So Martyn, each like to travelling while that way. Bex, thanks to you, and to Matthew, so thank you so much for your great insights and expertise, and I know that your contributions have helped us over the last few weeks towards bringing much needed clarity, I think, to our landlords in what seems to be a continuing complex and ever-changing, evolving topic. Of course, a sincere thank you as well to all of our landlords and partners who've joined us today. We really appreciate you taking the time to join us. We hope you found the session helpful and informative, and hopefully if you have any questions that you'd like to raise, that you get in contact with us, and we'll be distributing contact details to you shortly. And before I wrap up, I would like to remind you that here at Legal for Landlords, and also through the buy-to-let broker, we do have a range of products and services that are designed to help future-proof your rentals in the weeks and months ahead. These will include our guide to the Renters' Rights Bill, which we're constantly updating with Martyn's support, and our landlord compliance audit, as Martyn mentioned earlier. It's going to be essential that all of the legal documentation is absolutely spot on. So gas safeties, EICRs, EPCs and so on, they are going to need to be registered on the new portal, which Martyn referred to. So we will be offering all of the attendees of today's webinar a free landlord compliance audit, and we'll be distributing how you would get hold of one of those. So this will check that all of your documentation is fully compliant. And finally, our rent and legal protection products, which I think is going to give you an extremely useful peace of mind in an ever-changing market. And we have our specialist insurance team on hand to support you and give you advice with all of those products available. So if you'd like to find out any more about any of these products and services, please don't hesitate to get in touch with one of our team, and you'll be able to see how to do that on our website. So thanks again for joining us. We really look forward to supporting you as a team over the next few weeks and months, and look forward to also chatting to you on the next in our series of our Renters' Rights Bill webinars. So thank you everybody for today.
Thank you.
Thank you.